Good afternoon, everybody. My name is Michael Coviello. I'm the Associate General Counsel for the National Fraternal Order Police Division of Labor Services, and this is part of our new webinar series that we're going to be presenting on a regular, at least quarterly basis. We are very privileged today to have two wonderful presenters, two fantastic attorneys out of Indiana who have always provided great support for the Division of Labor Services, Fraternal Order Police, and for police officers. We have John Kautzman and Leo Blackwell out of Indianapolis, Indiana, and their law firm. And we are going to be able to take your questions. I will provide the questions to the presenters for their answers. We'll do that on an interval basis. And at this point, I'd like to turn it over to John and Leo. And thanks very much, gentlemen, for joining us today.
Thank you, Mike. On behalf of Leo and myself, this is John Kautzman. Leo and I practice law with RUCKELSHAUS, Kautzman, Blackwell, BEMIS, and HASBROOK in Indianapolis. We are a 7-person general practice firm with a heavy emphasis in public safety representation. And we do all different kinds of work from legislative efforts and lobbying at the State House on the interests of fire department employees and police department employees. We also do litigation, both criminal litigation and civil rights litigation, disciplinary actions all across the state of Indiana, because we are also the general counsel for both the state FOP and many local FOP lodges as well as the State Firefighters Union and the Indianapolis Firefighters Union. Leo, anything you would add to that?
Well, I'd like to say that we extend our sincerest appreciation to National FOP President Chuck Canterbury, General Counsel Larry James, and Associate General Counsel Christina Coral for providing invaluable resources in the preparation of this PowerPoint and the sharing of information that goes on. Additionally, we'd like to give thanks to our Labor Services Director, Rick Wiseman, for his tremendous assistance, as well as Associate General Counsel Mike Coviello.
All right. Folks that are assembled with us today, we're going to jump right into the issues on our presentation today. As you know, this is meant to be an informative session on how Brady versus Maryland affects employment implications for police officers. And what we hope today to do is cover several issues that we hope that will help you in your practices for the lawyers that are on the line with us today, and help you in your job situations with the police officers that are on the line with us today. The first thing we want to be able to cover today is the case, the facts, and the rule that were articulated by the case in Brady versus Maryland, and talk about exactly what that case should mean to you. Then we're going to talk about the administrative impact on public safety and how these issues can affect your job situations and the job situations of your members. We'll talk about what specifically must be disclosed and how those disclosures come into play with regard to how it affects a police officer's employment. We'll talk about officer discipline and specifically the formation of Brady lists where prosecutors and departments are starting to keep tabs on what officers can be trusted for use in cases. We will talk about the risks of personal and departmental liability with a rash of civil lawsuits that are now starting to flow from Brady obligations. And then finally, we'll wind up by talking about what you can do in terms of advising your members on protecting themselves in this very difficult and evolving area of case law. So first of all, I'm going to have Leo talk a little bit about what Brady versus Maryland is, the core of the case.
The Brady decision, which was handed down in 1963 in Brady versus Maryland, really stands for a very simple proposition that if there is some evidence that would be exculpatory in nature or go to prove innocence or at least lead a jury to believe that one might be innocent, there has evolved this duty to disclose that to the defense well into the process, and that's really the nut of this whole presentation. It's the due process clause of the United States Constitution that comes into play. In Brady, This includes sustained findings of untruthfulness of police officers or witnesses that might be known to the prosecution. In short, an officer's personnel file is always going to be fair game for criminal defense attorneys to impeach a police officer on the witness stand, because the officer's credibility is a material issue, and lack of credibility is potentially exculpatory by its very nature. The facts of the Brady case: there were two men, Brady and Boblet. They were found guilty of first-degree murder and sentenced to death. Brady admitted participation in the crime, but said that Boblet did the actual killing of the victim. Before trial, Brady's attorney requested Boblet's extrajudicial statements from the prosecution. The attorney was given some, but not all of those statements. And one missing statement was Boblet's confession to homicide, which now, looking back, seems like that really was a no-brainer to disclose that. But at the time, the prosecution felt that it didn't need to be disclosed. The evidence was not discovered until after Brady was tried, convicted, and sentenced to death. The issue was whether Brady was denied a federal right after the Maryland Court of Appeals remanded the case for a new trial on the issue of punishment only. And of course, the holding was that prosecutorial suppression of Boblet's confession violated the Due Process Clause of the 14th Amendment of the United States Constitution. That is the sum and substance of the facts and what leads us on this journey through the case law and brings us home to where we are today.
So let's go a little bit deeper into the progeny of Brady. Subsequent to the Brady case, the U.S. Supreme Court held that evidence which may be used to impeach the testimony of a government witness falls within the ambit of Brady when the credibility of the witness may have an effect on the jury's determination of guilt or innocence.
Hey, Nicole, can I please speak with PJ?
And that was the Giglio case, Giglio versus U.S. 1972 case, and later affirmed by U.S. versus Agers. Essentially what we then have is the Supreme Court modifying what was the existing Brady rule to now require the government to disclose exculpatory evidence even when the defendant had not requested that information. And so we have kind of this dual-headed Brady-Giglio requirement that comes out of the case law that clearly now extends to police officers called by the government to testify. So what's the bottom line? The bottom line there is that if you as a police officer, or if you're advising people that are in police employment, what happens with regard to their credibility, whether or not specifically they've been found to be not credible or untruthful in previous investigations, becomes something that can be turned over to the defense to be used for impeachment. And because of that, Brady demands that that in fact be done so that the defense is entitled to use that information to try to show to the jury the lack of credibility of that government witness. The government witness, of course, in this situation being the police officer. Now, you get into questions dealing with the timing of these disclosures, and they're going to be different based upon the kind of prosecution you are involved in. From a state standpoint, if you're in a state prosecution, the timing of the Brady disclosures normally are going to be in sync with state discovery disclosures. Now, I caution everybody on a webinar such as this that you may have certain state laws that will vary from jurisdiction to jurisdiction that would affect the timing of those disclosures. But typically in a state prosecution, the normal discovery route is going to be how you learn of or what the timeline is for the disclosure of Brady-type material. In the federal jurisdiction, it's going to be different than that, and it's going to be largely dependent upon things like the Jenks Act. Now, this webinar does not allow us the time to go into the fine lines and the fine details of Jenks and all that federal procedural issues that are going to come into play there, but suffice it to say that in a federal prosecution, you may be in a situation where through normal discovery you can receive some of the information, or some of the information has to be turned over with regard to these Brady-type disclosures. But if that disclosure has to do with a specific witness on the stand or a specific witness that a specific statement that a witness made, then the Jinx Act may mean that that will not even be turned over until after that person testifies on the stand. The bottom line is that you as advisors to these police officers and to departments that are turning this information over have to be aware of and instruct officers on the appropriate timing so that you make valid disclosures in a timely fashion. So those are things just to keep in mind on how this practically comes into play with regard to the timing. We want to now move into the issue of what does need to be disclosed. The first thing that should jump out at you is what is the degree of disclosure that's required? How much needs to be disclosed? Well, the case law seems to say that everything does not have to be disclosed. It has to be some kind of a test of materiality and relevance has to be met before disclosure is absolutely required. Especially the case law, including cases like U.S. versus Bagley and Kyles versus Whitley, talk about the fact that it only needs to be disclosed if it's suppressed, it would have deprived the defendant of a fair trial. In other words, that failure to turn over the information really had an effect on the outcome. It's clear, for instance, in the Kyles case, that unless it would reasonably affect the outcome of the case, or where the suppressed evidence could reasonably be taken to put the whole case in such a different light as to undermine confidence in the verdict, then disclosure would not necessarily needed to have been required. So generally you want to err on the side of disclosure because you don't want to get yourself in a box with regard to a failure to provide Brady information. However, there are limits to it if it's not material to whether or not a conviction would be sustained or not. The next issue is in trying to determine what you can go for in trying to get Brady-type disclosure, you have to ask yourself, can I get the entire personnel file, or are there other things that have been turned over to me that seem to be incomplete and there's more information that should be out there? Cases seem to be kind of across the board on how this issue is going to be handled. I would direct you first to a case called United States versus Henthorne, which is a Ninth Circuit federal case, and it kind of talks about kind of a wide open disclosure rule where the fact that the inquiry is being made meets a sufficient test of materiality and relevancy to have that information provided. Specifically in this case, the court was confronted with the issue of what type of information was in the personnel files and what amount of that information had to be released to the defense. In that case, the defendant requested the prosecution to, quote, produce the personnel files of all law enforcement witnesses who had intended to call at the trial for evidence of perjurious conduct and other like dishonesty in camera to determine if those portions of the officer's personnel file ought to be made available to the defense for impeachment purposes. In this particular case, the trial court denied that request and the case was appealed, and on appeal the Ninth Circuit reversed and remanded the case, citing that the prosecution was incorrect in its assertion that it is the defendant's burden to make an initial showing of materiality. The obligation to examine the files arises by virtue of the making of a demand for their production. So as you can see, the Henthorne court clearly decided that we were not going to place the burden on the defense to have to kind of guess what's out there and make a specific request for production, that the burden was going to be upon the state to produce anything that could reasonably be viewed as material. I want to contrast that then with some other cases that are coming out of primarily the 6th, 7th, and 11th circuits. those cases seem to say that personnel files need not be produced without sufficient evidence from the defendant that impeaching or material evidence is contained in that personnel file. In other words, mere speculation that a government file may contain Brady material is not sufficient to require a remand for in-camera inspection, much less reversal for a new trial. That court said that, quote, a due process standard which is satisfied by mere speculation would convert Brady into a discovery device and impose an undue burden upon the district court. Now, interestingly, I think all of us think of Brady as a discovery device, but some of these cases are not wanting to treat it that way and are wanting to treat it a little more gingerly and not shift everything onto the backs of law enforcement and the prosecution. So,
John, we have a question with regard to the personnel files.
Yes, sir.
The question is, our agency has 3 or 4 personnel files, so are all of the files subject to disclosure?
Any personnel file that could reasonably be believed to contain information that bears on credibility would all have to be discovered and disclosed. That would be the test that you would apply to those personnel files. Okay? So,
okay, thank you.
The courts, as we say, going from Henthorne in the 9th to other cases such as Quinn and Andrus and Driscoll in the 6th, 7th, and 11th circuits are going to have differing outcomes based upon where you are. Now, going on with what needs to be disclosed, the question arises as to whether or not it's the information that is already known to the prosecution or information that maybe just the police department knows about and they've never disclosed to the prosecution. The Supreme Court, in this case, has once again laid down some cases that talk about how this should be analyzed. The Supreme Court and the federal courts have expanded essentially this duty to disclose exculpatory and impeachment evidence to include information known only by law enforcement, even if the prosecution is unaware. So the basic rule is the prosecution can't hide behind kind of the straw man and say, well, the police department never told us about this information, therefore that's why we never turned it over to the defense. There is very few jurisdictions that are going to allow you to hide behind that kind of a situation, because it's going to require the prosecution and the law enforcement agency to work in harmony to seek out this information and divulge it to the defense, or otherwise you're facing a Brady violation. Accordingly, prosecutors are not permitted to claim ignorance and with regard to their duties, and they do in fact have a duty to discover information known by law enforcement. I would commend you to a couple cases, Youngblood versus West Virginia, a U.S. Supreme Court case that said that Brady is violated when the government fails to turn over evidence that is known only to police investigators and not to the prosecutor. And also the Kyles case, which says that prosecutors have a duty to learn of any favorable evidence known to others acting on the government's behalf, in this case including the police. Another issue that kind of goes along with this was talked about in a case that we found called U.S. versus Risha, a Third Circuit case. And what it had to do with is kind of a strange issue of whether a state agency's knowledge of Brady and Giglio information can be imputed to the federal government. And that obviously would be in a situation where you got a federal prosecution, but the information was being maintained in state law enforcement databases. The factors that would come into play here would be, number one, whether the party with knowledge of the information is acting on the government's behalf or under their control. Number two, the extent to which the party with knowledge and the federal government are acting as part of a team or participating in a joint task force or sharing resources. And number three, whether the entity charged with constructive possession has ready access to the evidence. All of those would be factors that would play into the need to disclose based upon those kind of joint task force operations. Leo's going to talk a little bit about how the U.S. Department of Justice handles it as far as their policy.
Well, I think that the United States Department of Justice has a blanket approach to this. They want to discover or to provide as much information as they possibly can to make sure that they CYA in regards to their exposure or potential exposure to liability for failure to turn this stuff over. And under that policy, each investigative employee has to inform the prosecutors of potential impeachment materials as early as possible before providing any sworn statement or testimony in any criminal investigation or case. And that would include, of course, sworn depositions. Investigative agencies must disclose certain information, and this is just how broad this policy is. If you look through these things, and I'll take you through them, you can see that very little is going to go unreported under this particular policy, and I see this as almost a template for even local agencies to follow when they're trying to decide how to handle this Brady issue, as more and more jurisdictions become aware of this situation and more prosecutors start to worry about their own exposure or the exposure of their office if they fail to provide this exculpatory or impeachment information. Under this DOJ policy, substantiated allegations, any findings of misconduct demonstrating bias or lack of candor or of untruthfulness. Well, that's okay, substantiated. We understand that. Pending investigations or allegations. These are credible allegations of misconduct that reflect upon the truthfulness or possible bias of the employee who's the subject of the pending investigation. Now, think about your own situations, you police officers in the audience and your co-workers. There may be some of those bogus complaints out there that have not yet been substantiated, but certainly go to whether or not that officer is truthful. And do they have to turn those over or not? Under this policy, they may well have to. If you look at the last bullet point, allegations that are unsubstantiated in some circumstances have to be turned over. Of course, criminal charges, past or pending. Many of our police officers across the country are facing criminal charges for a variety of issues, dealing with things in their personal life and occasionally in their professional life. And so we're really on a slippery slope as to what needs to be turned over and how soon. And it's going to be up to your individual prosecutors, and we'll talk a little bit more about that in just a little bit. The officer discipline and the Brady list. For you police officers in the audience, this is really the sum and substance of what's very important to you, is to know that this Brady situation, this Brady case law is out there, and the progeny of cases after Brady that require the prosecution to divulge or turn over this information. And so things that happen in your professional career that years ago might go completely unnoticed or unpublicized now must be ferreted out by the prosecutor and by your department and made available to the defense. And that is the most important thing to remember. And for you leaders in the FOP that are in the audience, you must inform your members of the importance of their absolute truthfulness in all of their dealings with their police department, because it will come back to bite you. There's a fine line between disclosure and discipline. In an attempt to comply with the mandates of Brady and protect cases from impeachment evidence, some state and federal prosecutors actually keep a Brady list. And I'm sure you've heard this bantered about, or you've read about it on the internet, and hopefully none of you have been subject to potential discipline or problems that might arise for being on a Brady list, but it could happen. And these are lists of officers who may be subject to impeachment and upon whom they believe that they, being the prosecutors, they cannot rely. Whether officers can be disciplined or terminated for appearing on such a list is an ever-evolving and in many jurisdictions an unanswered question. In response to this trend, something recently, California adopted Section 3505.5 to its Public Safety Officers Procedural Bill of Rights, which prohibits punitive actions or denials of promotion based solely upon an officer's appearance on a Brady list. I think that is somewhat of an anomaly. We have not received any information of this occurring in other parts of the country. And just take a minute to think about that. In California, they've said you can't take punitive action just because you appear on a Brady list. I would say that the rest of the country is following the trend that they can take and will take punitive action. So again, the caveat to our police officers in the audience is CYA. And the best way to do that is always be truthful, because these things will be made available to a prosecutor, and the consequences of that we're going to get into more detail on in just a few minutes. Now, the public policy under Brady and officer discipline comes into play because the courts in various jurisdictions have treated this in different ways. In some jurisdictions, being on a Brady list could be fodder for termination action brought against an employee. In others, not so. But we're going to go through a few of the cases. These are just important to know that it varies throughout the country. But for instance, in the United States, in Unified Government versus Wyandotte County, a police officer was accused of theft, and the district attorney determined that the charges were not supported. Well, that's good. Despite such a determination, the DA determined that the DA's office would not rely upon information obtained from the officer for future criminal investigations. Accordingly, the city then fired the officer. An arbitration panel, for those of you that have arbitration, you might pay attention here, found that the DA did not have the authority to de facto terminate the employee, and the officer was entitled to reinstatement. Likewise, in get this slide right, in Kitsap County Deputy Sheriff's Guild versus Kitsap County Sheriff, Deputy LaFrance was fired for 29 documented incidents of misconduct, including untruthfulness. An arbitrator heard the case and determined that the charges were accurate, but termination was not appropriate. The Court of Appeals overturned the arbitrator's decision as contrary to public policy. The Supreme Court of the state of Washington reversed the appellate court and held that decisions based upon public policy are limited to those decisions that violate an explicit, well-defined, and dominant public policy, not simply general considerations of supposed public interest. The Brady Rule provides neither an explicit nor a well-defined public policy against reinstating a police officer found to be untruthful. Thus, the arbitrator's order reinstating the deputy sheriff was not contrary to public policy. What does that mean? Well, in this case, the court said it has to be actually they didn't say written, but well-defined public policy. In many jurisdictions, we don't find that. You don't find it in your state statutes, and public policy is something like beauty. It's in the eyes of the beholder, and it's something like smoke. It's very hard to grasp.
Well, we can only hope that we, if we're defending police officers, live in either Wyandotte County or Kitsap County, because obviously the courts in those jurisdictions tend to favor letting the police officer keep his job. As we can see from some of the other cases, that doesn't always turn out to be the case. I would commend you to some of the other cases that found termination of the police officer to be proper, starting with the LaChance versus Erickson case, because there are law enforcement agencies that have taken the position that mere public policy condemns police officer dishonesty, and therefore that public policy justifies the termination of untruthful police officers. a concept, as you can imagine, that not only is now being accepted by the law, but is firmly rooted in what the public believes. And as you know, these cases can become media-driven public spectacles, and neither your FOP president or your police chief are going to be able to stand up in the court of public opinion and pretty much be able to deny that public policy shouldn't demand truthful police officers. So as you can imagine, it becomes a real problem, and it's underscored by these cases. In the LaChance case that ended up going to U.S. Supreme Court, there were a collection of government employees whose cases were merged into a single case. And on that consolidated action, which were appeals from a merit board that had reversed the terminations of federal agency employees based upon false statements given by those employees during internal investigations. The Supreme Court in LaChance held that a governmental agency may take adverse action, including termination, against an employee because the employee made false statements in response to the underlying charge of misconduct. So as a result of cases like this, several state and federal courts have held public policy does indeed support the termination of police officers who were found to have lied during the course of internal investigations. Similarly, a case out of Connecticut called Bloomfield, Town of Bloomfield versus United Electrical Radio and Machine Workers. It was a 2006 case where a police officer was found to have lied during the course of an investigation. Once again, he was terminated, and that termination was appealed. In this case, an arbitration panel found that while the officer was untruthful during the investigation, the termination was simply too harsh of a penalty. The Supreme Court in Connecticut said not so fast. In vacating that arbitration award that had reinstated the officer's termination, the court found that there was, in fact, a clear public policy in Connecticut that it is against public policy for a police officer to lie, and therefore they were not going to condone that kind of an action, and the termination was held to be proper. So as you can see, a lot of these cases fall on one side or the other of kind of a bright line distinction that's based upon public policy. This public policy analysis as it relates to Brady determinations, once again, is going to be very state law specific and very jurisdictionally specific as far as the outcome. But many cases are starting to utilize this within public policy, outside of public policy dichotomy and how they're going to rule. The bottom line to take away from this is that in cases that find a specific public policy against employing untruthful police officers, courts seem to rely on those specific state statutes and policies and uphold terminations. In cases finding no specific public policy favoring termination on those grounds, then the court did not necessarily find a state statute upon which they could base a specific public policy argument favoring termination. So once again, no broad generalized rules we can give you in this area. It's going to have a lot to do with what jurisdiction you're in and how you can make an argument to tailor your particular police officer situation for the facts of this case.
John and Leo, there's another question that's relevant to the idea of review, post-list or post-adjudication review. And here's the question, and I believe it comes from Maryland. But additionally, do you have knowledge of the Fields and Cockley v. State case where two Baltimore City officers had a sustained finding in their IA file, but the case never went to a hearing board for adjudication, but was later closed administratively? In the case, they speak of an in-camera review process for the files to be used. What is an in-camera review process?
Well, an in-camera review process typically refers to, in litigation, a judge reviewing the information and making an in-camera or private determination based upon that judge's review of the information as to whether or not the information meets whatever test is applicable. What that usually does is prevents the inquiry or the examination taking place in public or in a public courtroom, where if the court would determine that this is rank hearsay or rank speculation, and I'm not going to let the local news media go out and write about this when I don't believe that this information is credible, then many times it's very helpful to have these reviews done in camera. So that's typically a good thing when you can at least force the court or the arbitration panel to do an in-camera review rather than air these things out in public. Now, having said that, the first part of your question, Mike, also made me think that you have to be careful to make sure that there was truly some kind of a finding of untruthfulness against the officer, because the lawyer that's advising that FOP may want to challenge some of these things based on the fact that some supervisor has made a conclusion that an officer is untruthful, but the officer really didn't have a chance to have his quote-unquote day in court. He didn't have a chance to at least air this out in front of a merit board, have kind of a due process type hearing to see if he truly was untruthful or not. So that would be another attack that you would want to make before someone could try to run with that untruthfulness finding. But generally, in-camera reviews are helpful to protecting a police officer's right and his reputation in this area.
And I think, in further response to that question, I believe that case involved the defense attorney's request for an in-camera review of personnel files, and the judge denied that request, and it was for that reason that the court said that an in-camera review was a way to handle that, and that the defense was entitled to that review so that the court could decide what needed to be provided in terms of Brady and Giglio and what did not. Now, if I'm thinking of the correct case, but an in-camera review is just as John described. It's an opportunity for the judge to make the decision without making those documents public.
All right, so now we're going to move into an area that Leo's going to talk about initially here, and that is how do these Brady-type determinations and officers being deemed Brady officers or being on a Brady list, how does that play into what a department is going to do with you? Are they going to deal with it right up front with certain types of disciplinary actions or termination actions based upon different state statutes or local department rules and regulations? Leo?
Well, and we pose the question to you, what about states that consider a violation of department rules grounds for termination, or such as Indiana Code on your screen there, 36834B2B, and certainly most police departments, and it's common sense, they require truthfulness as a condition of employment. My goodness, in applying for a police department, if you're found to have falsified any of that information, you're not going to get on. And you take that to the next level. If you're found to be untruthful in your scope of employment, you may not stay on. So is untruthfulness a violation of rules and regulations within your department? And is that in and of itself sufficient to justify termination? Well, we believe that we're seeing more and more of this where because of a statutory regulation requiring truthfulness, or because of capacity issues, police officers are being subjected to a disciplinary process up to and including termination for what could be considered being on a Brady list. What if a prosecutor refuses to accept cases or testimony based on concerns over Brady officers or Brady lists? Does such a determination affect the officer's capacity to serve as a law enforcement officer? And again, we'd refer you to the Indiana Code as an example, but each of your own individual states probably have similar statutes. And again, there is no bright line. It is handled jurisdiction by jurisdiction, but it is something that we all need to be aware of, and you police officers that are out there every day have got to realize that certain decisions that you make concerning truthfulness and veracity could be truly career-ending decisions, in the long run.
And as you can imagine, especially in a situation where a department goes after an officer due to capacity, it can even arise in a situation where your department is supportive of the officer, but the prosecution is not. You can have situations like we had in Indianapolis where the department basically either thought that it was not a true finding of untruthfulness, or it was kind of a lame finding of untruthfulness based on a non-material issue, and the department was not necessarily going after termination of the officer. But when they learned that the prosecution had kind of put this guy on an informal Brady list and said that we're not going to use him in any more prosecutions, and we can't take any cases to court anymore if he's on the witness list, they were forced to say, well, maybe he is now incapable or has no capacity to serve as a law enforcement officer. So that then raises a whole new can of worms where Leo and I would have to go in and say, well, does that really constitute capacity? I mean, he's a officer of the proper age and experience. He is still certified by the Indiana Law Enforcement Training Board. All those things seem to provide that officer capacity to serve. Yet from a practical standpoint, a very practical standpoint, if he's going to be an investigating officer or a detective that is going to be called upon to testify in court to put criminals behind bars, they're going to say you're no longer having the capacity of carrying out your duties. So these are going to be very, very difficult situations for the police officer and for the lawyer representing the police officer in that situation. Okay, what about personal liability and departmental liability based upon these Brady obligations? Where does that take us? As it might not surprise you, criminal defendants have now become wise to this developing area of law and have begun to file 1983 claims against officers and agencies where they claim that potentially exculpatory information was not disclosed. This can include general exculpatory information and information regarding an officer's truthfulness. So they get convicted. They then believe that there was something about that cop that they later heard in the neighboring jail cell that they didn't know about and didn't hear their lawyer try to impeach the police officer on the witness stand about. So they start filing lawsuits saying that I think that there was Brady info that didn't get disclosed, and therefore I want to set aside my conviction, and if I can't do it, then I want some money for the violation of my civil rights. In this context, we are seeing two types of liability arise, at least in the civil arena, arising from Brady. One would be what many of you might be familiar with is the Monell Doctrine. Those cases would be a law enforcement agencies or a city or a municipality. There's systematic failure to comply with Brady requirements, which can be found to be a pattern and practice of illegal conduct. So those whole pattern and practice cases under 1983 that questions whether or not the agency or the municipality is conducting their business in a way that violates rights. This can be one of those examples. If they conduct their business in such a way that they uniformly fail to turn over information that should be disclosed under Brady, that can lead to liability under the pattern and practice cases under Section 1983 of the of 42 USC in the U.S. Code. The second way that this can come about is in failure to train cases. As you know, law enforcement agencies typically have a duty to adequately train their officers, and they can incur liability if they fail to train officers. Well, that training is not only handcuffing procedures, but it's also knowing the law and knowing what needs to be disclosed. And so if the municipalities aren't properly training officers and specifically supervisors as to what their requirements are in how and when to disclose potential Brady information, that also can lead to civil liability claims that are being filed. Now, that's kind of the backdrop of how someone gets into the courthouse. The cases seem to then go down a further split in the road based on whether or not the failure to turn over the information was the result of bad faith or was not the result of bad faith. Some circuits require bad faith to be proven on the part of police officers or other governmental agencies to demonstrate the entitlement to damages pursuant to Section 1983, while some circuits do not require this bad faith requirement at all. So the next screen kind of points out just some of the citations for cases that have broken down these lines. The Tennyson case, the Brown case, and the Steidle case, and the Moldowan case, those four cases all basically stood for the proposition that disclosure was required and it didn't matter if bad faith was present or not. The other cases, the White case, the Porter case, and the Jean case, basically came down the other side of the fence, requiring bad faith before that determination and disclosure occurred. So let me talk briefly about some of these cases without going into too much detail because I've given you the cites on these cases. Tennyson was a San Francisco case. Once again, a civil rights case filed by two men who wound up serving 13 years in jail on a conviction for murder before being set free based upon a finding of factual innocence. A suit had been filed against the San Francisco Police Department and two homicide inspectors who allegedly withheld exculpatory evidence and manufactured evidence. The homicide investigators claimed absolute and/or qualified immunity in the case, and in finding no immunity, the Ninth Circuit held that it was not required that those plaintiffs demonstrate bad faith on the part of the investigators. Instead, it was sufficient if the plaintiffs could demonstrate deliberate indifference or reckless disregard for an accused's rights or for truth in withholding evidence from prosecutors. So that's kind of a lower standard that is being put in place once again by the Ninth Circuit. In the Brown case out of the Fifth Circuit, a case where a lab tech had suppressed blood test results that were exculpatory. Brown then served 2 decades in prison for rape before the DNA results led to his acquittal. Brown filed a 1983 action against the lab technician for suppressing that information, and the Fifth Circuit refused to grant governmental immunity to the lab tech on the grounds, once again, that deliberate concealment of exculpatory evidence gives rise to liability under 1983, and no bad faith specific requirement had to be shown. Similarly, Moldowan versus City of Warren out of the Sixth Circuit. A similar deal as the last couple ones. Once again, no showing of bad faith was necessary in this case on a constitutional violation to overcome qualified immunity. That court specifically held that, quote, where material exculpable evidence is concerned, the mental state of the government official withholding that evidence is not relevant to determining whether a due process violation has occurred. Well, obviously, if the mental state doesn't matter, then they don't have to prove bad faith to have it turned over. Similarly, under Steidle, Seventh Circuit, here in our jurisdiction, no qualified immunity was available in the 1983 case for failure to disclose that evidence. The plaintiff only had to establish the duty of law enforcement to disclose exculpatory evidence, and the court in this case held that that duty was well established. Now, that's not the only breakdown you're going to get in these cases, because once again, you're going to find some jurisdictions that have much more of a requirement that bad faith be shown before these kind of protections kick in. Leo?
Well, again, what we're demonstrating here is that a lot of these things vary from jurisdiction to jurisdiction, court to court, and for you law enforcement members, it's not so important that you know all the case citations. It's just important to know that in some jurisdictions you may have to have a bad faith requirement, and in many you do not. And when we get down toward the end of this presentation, and we're coming close, we'll kind of give you some pointers on what you might consider to do as leaders within your FOP or on behalf of your own members and your co-workers to know what to expect when you get into dealing with a Brady situation. These cases are, again, and I'm going to do them very quickly, bad faith required cases where the courts have said that there must be a showing of bad faith. In White versus McKinley, the Eighth Circuit case of 2008, the plaintiff was charged and convicted of child molestation. the defendant police officer who investigated the molestation charge developed a romantic relationship, and gosh, you hadn't done that, with the child's mother, and as a result, the officer was accused of withholding exculpatory evidence. The prosecutor in that case was made aware of the relationship but failed to disclose it to the defense, and again, he probably made a decision that it had no bearing on the case. In describing the necessity of a 1983 claimant, that a 1983 claimant demonstrate that the police officer acted in bad faith, the court stated, failure to disclose exculpatory evidence does not constitute a denial of due process in the absence of bad faith. The Eighth Circuit went on to hold that the issue of whether the officer acted in bad faith was a question for the jury and that it had to be decided by the jury. And in Porter versus White, Porter versus White, this will come up on your screen in just a second, I believe. Yeah. That is an 11th Circuit 2007 case in which it was held that a 1983 plaintiff must prove that a law enforcement official acted in bad faith without withholding exculpatory evidence in order to state a claim for deprivation of his constitutional rights. In Jean versus Collins, a 4th Circuit 2000 case, the 4th Circuit held that the police officers were entitled to qualified immunity because a 1983 plaintiff failed to show that the police officers had the requisite bad faith in failing to disclose the fact that the testimony of the eyewitnesses had been enhanced and influenced by hypnosis. So you can see how far out this stuff can get. And again, it's a jurisdiction by jurisdiction, court by court decision, and there is really no bright line or standard.
All right, so where are we? What's the takeaway on what you need to know about Brady versus Maryland and how that implicates employment considerations for police officers? We've tried to develop kind of some tips and some practical advice for FOP members and for FOP leadership in how to deal with these situations. And as we have said so many times in this presentation, there's no black and white rules on this situation. Many of these are fine distinctions with a lot of gray areas. But we think that if you keep in mind some of these general tips, you'll be well on your way to at least properly assessing how a Brady situation is going to affect you or your membership.
And in doing so, I think you have to actually do that evaluation as an FOP leader in your community or an interested police officer in your community if you're not a well-organized or have strong leadership within your FOP. You have to assess how your prosecutor or your district attorney views this whole subject matter, and notice that we've highlighted in yellow there, determine whether the prosecutor or the district attorney in your jurisdiction keeps a Brady list or designate disciplined officers as Brady officers. In making these inquiries, you may tip off the prosecutor to something that they're not even paying attention to yet. So as a practical pointer to you police officers in the audience, you might want to do this cautiously depending on where you are. But understand that the legal obligation under Brady is there for a prosecutor, and it can really affect a conviction of a criminal if it's raised by the defense and if it's properly brought before the court.
Now, obviously, what you want to do in those situations is make sure that your prosecutor's office is properly turning over Brady information so that there's no later allegations of Brady violations and there's no civil liability for you or your department. But you also want that prosecution not to become anti-police officer and anti-police department by kind of going hog wild on the topic and then saying, oh, well, now that we're doing that, we're also going to keep Brady lists and start failing to recognize that we're going to deal with police officers on this list. So you want them to be doing their job, but you don't want them to get so overzealous in their job that they go hog wild on a Brady list. And that's something that might be that you have to treat with kid gloves in your particular jurisdiction.
And that's why it is crucial, we we believe, to have a working relationship wherever possible with your prosecutor. And the old adage of elect your friends and defeat your enemies could never be more important than when it comes to saving a police officer's job over this Brady material. And then sharing this information and the consequences of it with your membership is important, because we must instill within the law enforcement community the absolute requirement of truthfulness and honesty. Whether there is a stated public policy as such or a statute requiring it, it is common sense that police officers should be allowed to perform their jobs, and in order to do that, they must be trusted by the community. And in order to be trusted by the community, they must be believed to be truthful and seen as honest and upstanding people.
And as you can imagine, any position to the contrary is simply indefensible. Your FOP leadership cannot defend anything to the contrary, nor can the prosecutor or the police chief or the mayor.
So counsel your officers concerning discipline that they may be facing for untruthfulness or credibility, as to the gravity of charges and the potentially career-ending consequences of their decisions. And to do so, it's too late when that police officer says, "Oh, I screwed up. I falsified a report, or I failed to disclose to the prosecutor this particular piece of evidence," or the lab technician says, "Well, I knew that the DNA didn't really show that, but I kept silent." Those are things that are going to haunt your membership and give law enforcement a black eye. And it is too late to counsel a member when they're in their office, in your office, saying, "I got screwed up and I've got a Brady issue that the prosecutor has called to my attention. What do I do?" You need to be proactive and make sure that your guys are aware of this, and the men and women out there realize the importance of absolute truthfulness in all situations as police officers. And then you must work with your department to ensure that the disciplinary charges unrelated to truthfulness or credibility are clear, and that officers are not overcharged. Don't let them just paint with a broad brush. Again, it's important to have a working relationship with your administration so that they understand the importance of, if they have to bring charges against someone, they should be striving for accuracy and not overcharging. Now, points to remember for all law enforcement officers is always disclose information to the prosecutor which may be exculpatory. In most criminal cases, evidence and information regarding your truthfulness and your credibility is required to be disclosed to the defendants. Even the appearance of an impropriety in your record can subject you to being placed on a Brady list or impeached at trial. And there is little more embarrassing than being impeached as a law enforcement officer in a criminal trial.
Now, finally, make sure that you recognize the potential for career-ending administrative action if you're accused of any of these kinds of untruthfulness allegations or dishonesty allegations. Educate yourself and your members about the seriousness of the situation. And frankly, you should attempt to avoid any sustained findings of untruthfulness or dishonesty on your record in order to preserve your employment record. And what this may lead to in this area, as this area of law continues to develop, you may be in a situation where you get charged with a disciplinary action and you've been alleged to have done 3 or 4 things. Well, let's say one of those things is that you were untruthful. The police officer and the counsel that's representing the police officer sometime will have to make a decision on whether or not we want this case to go to a merit board and whether or not we want to risk a possible bad decision out of the merit board. You may be in a situation where this almost leads to more plea bargaining, if you will, in the disciplinary arena, where if you can work something out to take de minimis discipline for committing some act, It may be something that you think is more discipline than you want to take, but it may be worth swallowing your pride and taking an extra day of discipline if you're able to cut a deal that allows you to have the untruthfulness charge withdrawn from your record. And, you know, the way you would cut the deal, obviously, is I'm willing to plead guilty to count 1 against me on violating such and such rule and regulation on the department because you failed to act in a certain way, as long as they're willing to withdraw and dismiss counts 2, 3, and 4, one of which was an untruthfulness count, because you got to do everything you can to make sure you avoid a sustained finding on that count. That's all we have as far as a formal presentation. We stand ready to answer any questions you guys have. If, Mike, you can relay anything to us from the attendees. Otherwise, we really appreciate your attention today.
We do. We have some very good questions here. There are a couple that I'm going to try to decipher. There aren't that many, so we should have time to go through them all. Would you recommend a police department develop a Brady policy when the Attorney General's office or DOJ in their state does not have a policy?
Leo?
Well, again, I don't know that it's the police department's duty to develop a policy dealing with Brady. It's really that of the prosecution. I would recommend that the administration in that situation seek a clarification from their prosecutor, and if the prosecutor says, oh yes, we're aware of Brady and we do keep such a list, then you work to get a policy in place in that department. But I'd let the prosecutor be the driving force in that, at least the determining factor.
I also think it's important, before we go any further with answering questions, that everybody acknowledge, I'm sure Leo and John, you would say this, that whatever local issues may arise, the jurisdiction-specific issues, we're only giving you an overview here of what the law is in general. We can't give you legal advice in your specific jurisdictions because we're not all licensed in the jurisdictions from which you're asking these questions. So whatever we tell you, we would emphasize that you need to contact local counsel to review any specific case-specific questions. Next question, will you clarify what information can be considered as part of an officer's record regarding credibility? For example, are performance evaluations or performance duty notes applicable?
Well, you know, as Leo had mentioned when he was going through the U.S. Department of Justice policy, that was a pretty good template as far as the things that need to be turned over. As I said before, it's really tough to clarify in any specific situation what needs to be turned over. But what you just mentioned, Mike, could certainly have entries or recordations having to do with things that bear on credibility. So if that is in fact true, then that would be something that meets the Brady test of most jurisdictions and would have to be turned over.
So
if it goes to truthfulness and veracity and their quality of fitness for duty, because they're known for their accuracy. And I think a performance evaluation where a guy shows up late or fails to make a report, certainly not. But if a guy is found to be not truthful in those reports, and that's part of the evaluation, then yes, that would be information that should be turned over as part of a Brady request.
And you know, Mike, this also goes right into that issue of trying to protect the officer's record. If in fact the performance evaluation says that the officer is frequently inaccurate in his reports, well, is that inaccuracy due to inattention, or is it due to deliberate lack of honesty and truthfulness? Someone's got to make that determination and make sure that if it's inattentiveness or sloppiness, that doesn't then turn into a Brady violation.
Okay. When you discuss sustained findings, quote unquote, are they still considered such if they are reversed in an arbitration or as a result of an agreed settlement?
I think our position would simply be you got to take kind of the best hand that you're dealt and try to run with it. Leo and I fear that an initial determination of untruthfulness, if it was sustained by whatever your disciplinary board structure is, even if it gets overturned later, your disciplinary board made that finding. Now, that's the attitude to take if the prosecutor is going to err on the side of disclosure. I would argue that if your disciplinary scheme allows for a review process with an arbitration board or a court in a judicial review, for instance, and the arbitration board or the court overturns that finding, then I would embrace that higher finding and take the position that, I'm sorry, there hasn't been a sustained finding of untruthfulness because when we went through the available review, it was overturned. But I think you got to pretty much seize on what is the best suit for you to play and go with.
Okay. What particular concerns do you see for frontline supervisors, typically sergeants, as it relates to these issues? I suppose what the question is asking is if there's a subordinate officer who is not necessarily performing up to par and the supervisor has a reporting obligation vis-a-vis the job, not necessarily to a prosecutor, and what liability would a supervisor have for not blowing somebody in, I suppose, would be the question.
Well, I think it only goes to those sustained allegations. If a frontline supervisor feels that an officer who works for him, let's say, or her, is untruthful, and they don't report it up the chain or officially through their channels, and it's not discoverable, then it's like a tree that falls in the woods. You know, does it make a sound? If it's not a charged, a sustained finding, or as a competent allegation of untruthfulness, then I think it need not be disclosed. But again, that is going to be an integrity issue on the part of the frontline supervisor. I mean, if he feels he's got a scoundrel out there who can't be trusted, he has a duty under his oath of office to perform his duties as a supervisor and report that up the chain, in which case it does then become a discoverable Brady type of an incident or disclosure.
And remember, under those failure to train cases, if that information later comes out, that frontline supervisor isn't going to be able to say, well, I didn't know I was supposed to do anything with this knowledge that I had. There's pretty good case law that says they need to be trained on how to deal with that knowledge.
What happens with multiple files within the same county but not within the same law enforcement agency? Where does the obligation stop for the prosecutor or agency? I don't know if you understand that question. I'm not sure where we're going.
I think it kind of had to do with when we were talking about when is information imputed to another source based upon local databases. I think it's the same thing that applies, especially in this age of multi-jurisdictional task forces. If there's information from one agency that the other agency would reasonably be expected to rely upon, that's probably going to have a duty of disclosure.
Okay. What do you do if you have an officer with a sustained complaint involving departing from the truth in their file? Does that officer just prepare for potential impeachment and answer accordingly should that happen in court?
Sure. I mean, that's a good point. We've talked about the duties to disclose. We really haven't talked about how to handle it. Theoretically, what this would mean is that if that officer still has the confidence of their deputy prosecutor that they're going to go to trial with, they need to sit down with that deputy prosecutor ahead of time. They need to discuss the fact that now in discovery, we provided the following information out of your personnel file, which included X, Y, and Z. And if you are cross-examined on this issue at trial, how are you going to put in its best light why this information was seen to be as dishonest or untruthful? And hopefully there is a candid explanation that can point out how the untruthful finding was the result of miscommunication or honest error or mistake that can allow the jury in the new case to find that, well, I'm not going to necessarily consider him unbelievable because I understand how this previous situation arose. But that preparation for that cross-examination is very important.
What about the nature of the untruthful statement? For example, an extramarital affair may involve untruthfulness but is not job-related, or calling in sick when the officer is not sick. Is this different than lying about the evidence in a police investigation?
I think it's significantly different, but again, it will depend on the circumstances, of course, of each case and how that's viewed in that particular jurisdiction. If an officer has in his private life some indiscretion involving truthfulness, I don't think that is a disclosable issue unless it's been some sustained finding within your police department that impacts your job some way, in which case it may well be disclosed and could be grounds for putting you on some kind of a Brady list. But if it does not, I would argue that it does not impact your personal professional employment as a police officer, and therefore that's an unfair inclusion on a Brady list. However, there are no real rules and no handbook that each prosecutor, each judge, or each circuit will be following. So each incident or each case will be handled on a case-by-case basis. So it could be, and probably in that case it would not be, in my opinion.
We are having an issue in Maryland with this. An officer had sustained administrative findings for untruthfulness. However, he was exonerated at trial board. The state's attorney says he should be on the Brady list. We say he shouldn't. The follow-up question to that is, what are your feelings on this, which I think have been clear. But I think probably what we should ask is, what are the remedies potentially available to that officer when they're on a Brady list after they've been exonerated after the last step in the review process?
We've had, in the FOP attorneys seminar that is held annually and organized by the National Fraternal Order of Police, this very question has come up each year and debated at length. And again, depending on the jurisdiction, it's questionable how much authority the actual prosecutor would have just because he decides to put somebody on the Brady list. And there are all different ways, several different ways to try to approach that and attack it. But they all come down to local rule, I think, of the prosecutor and how you're going to deal with him. So I don't have a blanket one-size-fits-all answer. And apparently Maryland has some hot issues right there.
Should the police department submit the name of a police officer who has lied in an internal affairs investigation despite the fact that he is not a witness or a charging officer in a case?
I don't think there's a duty to submit that name until that officer is part of a prosecution package that is a witness or a charging officer or an arresting officer, in which case, yeah, then that would be discoverable, or not discoverable, but would have to be produced under the Brady theory. Until that time, I don't think you need to, I don't think a department would need to tell them of everybody who lied in an internal investigation.
And a related question, should an agency be going through its officers' personnel files and turning over any Brady information to their local prosecutor, no matter how old the information may be? The audit question, basically.
Well, my opinion is that they should not, and that it's not required under Brady. However, remember what we keep saying, there is no playbook for this. So if a department decides they're going to be proactive and get their list ready and turn it over to the prosecutor, there's nothing that says they can't. As a practical matter, I think it's ridiculous, but that's a personal opinion.
And now the other side of that same question, should all IAA cases with sustained untruthfulness charges be reviewed before the state's attorney for Brady lists? In other words, I suppose the prosecutor doing an audit of the agency's files of its own accord.
Again, that is a jurisdictional matter. If the prosecutor says, I want to review every swinging guy out there that has ever been found to be untruthful in these internal investigations, that he's going to have the power to do that. I don't think it's necessary. It's not required under Brady, but maybe a prosecutor would feel that that's his due diligence to know who's truthful and who's not within that police department. And we have seen some prosecutors give what I think is a knee-jerk reaction to this whole Brady thing and take it to an extreme, and that is what is the fodder for those discussions on the national level on how to deal with those prosecutors, and we haven't found a solution yet that I'm aware of.
Is this law just for police officers and investigators, or any law enforcement officer that may have to testify?
That would be any law enforcement officer who would have to testify as a witness in a criminal matter, whether they are the investigator or the arresting officer. If they are called as some kind of a witness or in any regard and put on the stand, they are subject to a Brady examination, if you will, and their name must be disclosed, and their credibility is at stake.
I'm not sure how much time you gentlemen have left to give to us. There's a handful of questions left. If you need to go at some point, certainly let us know, but until then I'm going to keep giving.
We still have a couple minutes, Mike. Let us know what you need.
Okay. Is there a time element from accusation to the review by the court to have any effect if there's a Brady violation?
Well, there doesn't seem to be any kind of like a statute of limitations whereby an old alleged Brady violation never has to be disclosed. It may go to that question of materiality or relevancy, and the more old the allegation is, the more attenuated the connection is going to be between the truth and the officer really having a truthfulness problem. But there isn't anything that says that just because the allegation is 5 years old or 10 years old that it can't be used.
Is the Brady list provided to the prosecution subject to data practices requests, or is it considered attorney-client communication?
Well, that's an interesting question. We haven't considered that. I would think that it's attorney-client communication between the prosecutor as the attorney for the state and the police department as part of the state and the client. But I've never seen that addressed in any of the cases. It may be subject to a FOIA request. I would doubt that, but I really don't know. Do you, John?
Yeah, and with the prosecutor's office being a public agency, they have higher duties of transparency, and I would be worried about relying solely upon an attorney-client privilege claim with regard to a public agency lawyer like that. So, I think you got to be careful with that.
Okay, this is one of my favorite questions of the ones I've seen so far. Is an individual officer required to self-disclose to a prosecutor information about themselves that is known only to them and not their department? What are the consequences if they don't?
I think probably the answer to that is, and not having seen any case law on that, is the following. Legally speaking, if they're self-disclosing because they're the only ones that know, there has not been a true sustained finding, and there probably hasn't been any corroborating information to the allegation, and therefore it probably wouldn't rise to the level of a material Brady violation that has to be uncovered. Conversely, if in fact that what the courts are going for is a transparency and a policy of candor and truthfulness of police officers, then if somehow someone were to find out that the officer knew and failed to disclose, that officer is going to run afoul of that. So I guess my short take is they probably don't need to self-report if it's just a mere something known to the police officer alone, but if it goes much beyond that, there's probably going to be a duty to disclose.
The next question is, you've answered this in some way a couple different times, but it's an interesting take. Is a supervisor's field file in which supervisors document coaching sessions held with an officer open to Brady requests? These files are not official personnel files, and the contents are not discipline as defined in the officer's contract. The files are simply used to document smaller issues that may be used during a performance review. I think we're confusing public records request with Brady information.
Yeah, Brady disclosure versus a wide sweeping public information request.
I don't think those types of notes would be discoverable under Brady. However, in some of the federal rules, the Jinx Act, for instance, which we didn't go into, those types of notes and things might be discoverable after that sergeant, let's say, was called to testify. They might, under Jinx, they would have to probably produce all notes and all diagrams and whatnot that might go to the subject matter for which he was called to testify and to which he did testify. So if that issue of truthfulness of that officer that he counseled were part of his testimony, then those notes would be discoverable under the Jinx Act and would have to be disclosed.
Is a prosecutor subject to a Brady review? That's a great question.
I'm not sure I understand the question, Mike.
I suppose any misconduct, prior misconduct by a prosecutor available to the defense and then admissible in evidence in a future criminal prosecution.
You know, that's an interesting question. I haven't seen it on the basis of where the target officer is a officer of the court, meaning the prosecutor. I mean, there's lots of case law that talks about prosecutors being a part of the law enforcement system, and I suppose if in fact there is a prosecutor that has sustained interagency findings of being a untruthful prosecutor, untruthful deputy prosecutor, that could be subject to use and disclosure. Now, whether or not it would be handled in this kind of a context or would be handled through the professional reliability or professional responsibility rules of that state is a different question. I mean, maybe that deputy prosecutor is looking at disciplinary sanctions as an attorney rather than Brady violation issues.
And I think he would be, because he's not a witness, and his testimony would not be that which the jury would consider, which could lead to a different result and tend to exonerate. So I don't think that the prosecutorial misconduct or history of such is a matter for Brady, but rather a matter for professional responsibility consideration by the Supreme Court of the state of jurisdiction.
And the prosecutorial misconduct line of cases that Leo was talking about.
Yes, yes.
Is a finding of taking a gratuity in one's personnel file Brady?
Well, a sustained finding of taking a gratuity, in other words, being on the take or accepting a bribe or whatever, I guess it depends on the details, but assuming that there's a rule and regulation that says thou shalt not do it, and he was found to do it, and that becomes essentially a crime of dishonesty under your rules and regulations, and I suppose that could be a Brady finding that would be sustained and then subject to disclosure.
There's a question about one of the cases that you were discussing on one of the slides. It stated the city fired the officer, but the decision indicated the DA couldn't fire him. Which entity did the firing?
You may need to point us back to which case, and maybe it's a typo. I don't know. Can you tell Mike when and how that case?
No, I think what we're talking about was where the arbitrator said that the DA did not have any authority over the officer as an employee, and therefore the decision to put him on a Brady list was not a termination offense, and therefore the reinstatement for the officer, irrespective of whether the DA wanted to use his testimony, irrespective of that, the employment decision was inappropriate.
I think that's right.
Okay.
I've got other commitments here this evening.
Yeah, we're giving everybody a 2-minute warning, Mike, and if you can summarize your final questions.
Okay. Let me see if I can find one or two more that have been waiting. We've already covered taking off the free list. Okay. I think we've gotten the meat and potatoes of pretty much everything.